Start your day.
Forums, and I'd never get it right, but I hope today I do.
You're on the hot seat.
Yes, I am. He who goes up must come down. I'd say it means the higher you go, the more important it is for you to never forget where you've come from and what truly matters. Because when you concentrate so much on the upscale politics and achievements, and you forget the struggles of, just climbing the ladder, you truly miss the point. I'd even reflect it on our president and government to ensure that even as they are navigating power, they should truly never forget their campaign manifesto and what they promised us. And it should reflect in the policies and laws that they are passing. Yes.
Yeah. Okay, how would you interpret it?
Well, I think man, meaning woman too, is built for seasons. Season to grow up at birth, you have to go to school, you upscale to university or whatever education, you start working. But then, obviously, it comes a time when you have to downscale, either in terms of activities, the robustness on contribution, and inevitably, you have to expire. I mean, we've seen big names expire. So it is basically a very organic proverb, if I have to say, because whether it doesn't matter who you become in life, you will be and you won't be one day.
Yeah. It's like a pendulum. Pendulum will go up, down, and up again. So it's just pretty much speaks about the proverb this morning, Asanteni Sana. Now, Wakili, we talk about the Land Amendment Act of 2025. It is a big conversation piece because many are asking, why should we care about this? We're being told everything. But you tell us, what is Land Amendment Act 2025 and what does it mean to the Mwananchi? Should we be worried that my land will one day just be taken?
I think yes and no. And I say that because in life, we don't need laws. Not even a single law. Because the prescription then would be the ideal that human has a predisposition to the good. And therefore, when you're born as a human being, you're predisposed to the good. And therefore, the adulteration of man's mind, and I say man, I mean woman too, would mean the society is the adulterer of the human person. Confucius theory around the same. So that today, if you see somebody is fallen down, a lady is walking and she falls down, unless you're really cruel, you run to help. The predisposition to help the next human being. It doesn't matter if you're a bank robber. When a lady falls down, you get attracted to what's wrong with this. In the village, when somebody dies, we all congregate to bury, and we come in our thousands, sometimes hundreds. All right? So that's the predisposition of man towards the good. What then adulterates and changes man is basically the competitive environment that the person is prescribed to, on account of the fact that you have to survive in a competitive environment at the lowest, at the highest, whether at the slum or in the city. So eventually, therefore, we carry ourselves within the same confine, the context being we compete every time. And when we do that, we suspect each other, and on account of the fact that there'll be extremes and our elasticity towards the boundaries becomes variegated of sorts. In doing so, then we make rules. Okay? So if I know that I have to drive on the left, I have to drive on the left. But I drive to the left and the right and the left. And therefore, there's a grind lock, and you have to make laws to say everybody drives on the left. Don't steal and take anybody's property. But because it happens, we legislate. So there are two types of legislative approaches which probably are dominant and we use. One is the mischief rule. The mischief rule is what is the mischief that is a possibility in the environment. So I would legislate it against it. All right? So then we say, it's possible that you're going to steal. So we legislate against theft. All right? The other one is the rule will be the natural predisposition of man on account of the fact that let's coexist, and therefore we make laws basically to say this is the environment that we're going to exist, especially the civil laws on account of economics, how we're going to make budgeting processes, and so on and so forth, right? So that those probably a cocktail of the principle and reasons why we legislate. Now you realize that the coercive laws are the mischief laws, and the others that generally describe relationships between man and government and man in the civil context and not the criminal context are basically slightly, because the usually law is the law, what it says, or prohibits, or coerces you to do something or not to do. But then there's a punishment that's prescribed as against it. So you realize that's the differential that we're looking at. Now come to the land law now. Land law, land is everything. Land is everything, and it includes the air, the land itself, the mass, and the water within the context of land. So that's the composition of land. When you legislate on land, you look at the very coexistence of man. Man must exist on land. Human beings must exist on land. Sorry, Madam, when I talk of man, no I continuously must be seen to be talking of the entire human race. Okay. Now, therefore, when you make laws on land, you're describing how we're going to manage land, the relationship of land ownership, land use, and the mobility of land as an asset that moves, the aesthetical value that moves, because land is land on its utility, and then there's an aesthetical value within the context of land that can move from one person to another, and the legislative environment. And the third one is the relationship between land, the land itself, and government, and the landowner and government. When you understand all that, then you realize that the economics of a particular community, society, or even government or country itself is based on land. All industries, everything, whether it's the port, the airport, a road, must be on account of the existence of land. Without it, whether you build something called expressway in the air or something called a tunnel and subway, still the context is land. And therefore, land being everything, when you legislate it, it must mirror everything in the context of the person as a private, the public, and the interactive aspect of the commercial exploitation of land.
And in that specific explanation that you've given, then one would ask the question, when we talk about the Land Amendment Act of 2025 that was passed by the President, we hear a lot of hue and cry out there in terms of there's some changes that have happened in the law that Kenyans are concerned about. So Abigail, I come to you and I ask, why are Kenyans concerned about this law? Mwananchi wa kawaida, why are they feeling like the legislation that is now law itawafinya?
Thank you so much. I think first and foremost, it's important for me to recognize that there was a lot of misinformation and we didn't have a very strategic communication from the ministry and government in regards to what they passed. First, they did it on a day we received the news of the death of the late Right Honorable Raila Amolo Odinga. So everybody panicked. From real estate itself, we felt the one thing that was being communicated across all our platforms, again because the government was not so clear about what had been passed by the president, was that all freehold land is going to be changed into leasehold land. And that spread. That was the first information that the public interacted with. And it's there, it's just not been passed yet by the president. It's been mentioned, and also it's been affected by county assemblies that have passed rural areas into municipality, which again changes how land is in terms of freehold and leasehold, and in terms of even how they pay stamp duty, because some places now are paying 4% because they are no longer just rural spaces, they are now municipalities, and the law is the law, yeah? So the first information Kenyans interacted with was government is changing all freehold land to leasehold, and there was panic. We only got the document that the president signed days later, and people are still not keen on reading it because they were still mourning Baba. So later, after you get that document and you had to really search it, you see they have it's a 4-page document, and what the president ascended was just the changing of, which is still very critical and affect what the NLC does, the National Land Commission, and takes away some powers and gives it to an individual who is a cabinet minister to be a custodian of very important documents, public documents, owing to the fact that the current cabinet minister and her history in terms of land and processes is questionable. And I'll say this because the last engagement we had with the cabinet minister of physical planning land, who is a woman and I respect her a lot, CS Alice Wahome, was her publicly trying to challenge and excuse the presence of her daughter, Wakili Wangeshi, in a land case that had just revoked title deeds of millions of Kenyans in Ruiru, the Kangaita Kanyotu land case. I know it was in the public domain and very many people talked about it. So now when a whole law has been passed by the president saying the cabinet minister of physical planning, land and housing will be a custodian of very public documents, you now wonder, excuse me, this is not what the law guides. Because there's a whole commission that has the obligation of being custodians of these documents. So that is what the president signed into law. There is the bill that is in parliament, the National Land Commission Amendment Bill. That one is the most chaotic and controversial of them all. One, it wants to enforce and give powers to the NLC to determine, revoke titles of any land that has ever been procured or bought or purchased or possessed by any Kenyan or institution or entity before the 2010 constitution was passed. And they're giving them a time frame of 5 years. So they're like, you deal with all these cases within a period of 5 years. They're protecting them so much and giving them even judicial powers and saying where the NLC open bank account and they can receive money and compensate, nobody can go to court to freeze those accounts or even ask for an accountability of what is happening in those accounts. So one, you are giving them judicial powers to sit, and this is a commission that has been appointed by, again, the same government. They are the ones to be now, sit and judge cases and make very final determinations and rulings, and you can't question them. And other stakeholders of the land and property ecosystem are not present. So in the National Land Commission, we don't have lawyers, we don't have surveyors, we don't have valuers, we don't have mediators, we don't have the real estate stakeholders there, the financial institution, the church. We don't have key people that should be sitting there so that when they're sitting down to discuss and just come up with, determinations, a whole ecosystem has been looked at. We've looked at the innocent buyer. We've looked at the people that are facing an injustice. We've looked at the legal aspect of it. We've looked at the financial institution that offered mortgages in those parcels of land, and so forth and so forth. That, the one that is in parliament, is actually what the public should be keen to digest, understand, and really fight, in my opinion. Yes.
Okay, I have a very simple question. Before we go into the legalese of these and the details of this act, you earlier in your intro talked about, we don't actually need laws as human beings. There is that inherent trait to do good in any environment, but because of greed, then either greed or fear, we end up doing things the way we do. My simple question is, before we go into these details, is I'm just trying to focus on those two things, fear and greed. In this case, whoever then comes up with this, whoever is suggesting this, either means well, or they're driven by something. Who stands to benefit in this? Because listening to what Zwena is saying, it's then very worrying if you're moving the center of decision making from a commission, you're laying it to an individual. Today is Alice Wahome, tomorrow it could be somebody else. It means something. It tells me there's something going on here. Why would you move it from point A to point B? What is the underlying factors here? What are we looking at here? Who is benefiting from this?
I think that's a good question, very good question, because in probably highlighting it to the public, this high vid, there is no legislation in this country from experience, because I have done bills, private member bills, I have done bills in many contexts. When you are being instructed to draft a bill, including the Attorney General doesn't wake up and do bills. She's instructed. So assuming you are the president instructing me, you're the cabinet secretary instructing me, or you're a sectorial disposition that is instructing me, what are you telling me? So we are from the real estate. This is how we suffer. This is how we want to protect ourselves. We are from the water sector. We have an investment from the World Bank. This is how we're going to protect ourselves. Okay? So continuously, and basically, I think predominantly, we have a constant, being that legislation in this country stems from an interest other than the general good, as you said. Okay? Now, when the instruction, lawyers, we're in a space where you have to be told to do, because that's a client. You have to be told to do. So when the government instructs you to do, it looks at first the context of what happens so the government survives. That's one. But that's a bigger picture. Who is government? The people in government cannot be you and me. It's supposed to be our government, but it's not. We know it's not. So the people in government, therefore, will instruct you to do something in order to preserve a certain status or to enhance a certain advantage. So there is no legislation, believe you me, that is merely general and innocent. It is instructed to be done. It is instructed. So then even a private member bill can be skewed on ethnicity. Look, I'm legislating this because our people. But before it becomes our people, you must have sat with your people and seen how you're going to compete with the rest of the communities to legislate on advantage on your people. It could be because you are positioned in a certain space and we are creating a certain position so that you move from there and you become a DIG or an IG or a director general or something. And therefore you're properly placed to take over that position and we legislate in order for you to take that position. The only innocence I see is when we were doing the Constitution. There were many interests, but you see, there was too much general for us to become specific in the construction of our Constitution. And therefore you realize that many people got lost. Even if you said, I'm going to put this position so I become the Prime Minister, I become the Deputy President, I become this, it all got lost, all right? Because then there was a lot of the general that then probably suppress the specific. It was very impossible to put a constitutional process with the longevity that it had in terms of its construction for you then to be consistent enough in character and position and obtain what was available for you. Here we have the quick fixes so that you can initiate a legislation now, 2-3 months, 2 weeks, you have it, 3 weeks. The longevity is shorter than a construction of a constitution. And therefore it's possible for you to plan around obtaining the advantage because time is on your side. It could be within the 5 years tenure of a certain regime. So you can legislate and obtain the advantage. I answer you this way, therefore, that this legislation was to obtain advantages to those that were interested in initiating it and having it to be passed in order to become an applicable law within a certain time frame.
Well, Wakili, and you've placed it well that there is a motivation and where it leads and who will benefit from that. Clearly not the public.
Yep.
And Zuena has highlighted that what has already been passed into law is that sort of a nullification of some of the responsibilities or duties of the NLC, and they're being domiciled now to the CS. She becomes the custodian of the title deeds, for example, of the public land. And we all remember there was a huge tiff when these, I have a slip of tongue when I say avoidable housing, but it's the affordable housing, that a lot of governors refused to surrender the public land, hence the title deed, to the CAs, because they felt this is public land and belongs to the people of those specific counties. Now that seems to be overturned, and the governors may not have so much power over securing the land that belongs to the public of their respective constituents. Therefore, I beg to understand as just a regular Kenyan. As you say, these are the beneficiaries, but what is the greatest danger that we are facing as Kenyans? Because public land is meant for establishment of public utilities and amenities. When that is misused now, and we are trying to, in a manner of speaking, address the historical injustices from 1895 to 2010, are we not creating more injustice based on this very customary, cultural, and emotive asset called land?
Well put. But let me explain to you this so that I open it up further for you.
Right.
we had a problem with our constitution. That's why we changed it. The biggest problem, although we have many acts and deeds that we say this was wrong, this was done by Moi regime, this was done by Kenyatta regime, this was by whoever it was there, fine. We can pick out acts, but that's not the point. The point is we are moving from centralism of power to devolution.
Right.
So what we did is we saw on a period of time, 24 years, 30 years, this is what was happening. So let's decentralize power. And I think the biggest problem, and I probably colloquially put it, the beef we had then was saying the president or do I say the executive had more power, let's decentralize. On matters of land, which is the context here, we then remove the president from the ability, because he had the ability to allocate land, for instance. Then we say cabinet secretary cannot do the following things, okay? And in the constitution, we basically even reprimand and basically prohibit, all right? But then down the line, you realize that when you're dispensing and executing your duties as executive, you realize you have bottlenecks. You know, law is not supposed to please anyone, including the executive. It's not supposed to please anyone. It's actually supposed to be an irritant that reminds you every day to confine to a certain policy. Okay? So when we took away the powers of allocation of land and administration of land completely, from the executive and dispatched it in custody of an independent constitutional authority called a commission, National Land Commission. The reason was exactly that, the mischief I was talking about. Now, you go around it and legislate so that then you domicile into the executive again what we said should not be there. In a sense, therefore, apart from that, because the things you can see and things you can see, that which you see being the affordable housing and the problems that come with it, including obtaining of land, because it's very expensive. You have to go to the private sector and obtain land from there, but the cheap one is the one that's available in the counties. However, what we've done in the constitution, we've given land to the counties, we've given private land, we've given communities. The government, the context of government land is really, really protected in the constitution. Now, what you do is you want to open that up and be able to make access, a penetrative access to those parcels of land, so that then either they are available for your utility. When they are available, you can abuse them if you so wish. Abuse means I can allocate it to you to do because I have given you the authority. It's legal. You told me I can give you the authority, I can. But we do know, like I've said, there's always an interest behind some of the decisions that are made. So you then can abuse that environment. This law, the suspicion we have on this law is predominantly to abuse it.
And I think that then I would ask as the public, because this is public land, this is our asset. Do we have room to appeal? Do we have room for reversal? Do we have room to prevent the reverse of the devolution or gains we have made, such that now this law can be repealed? Absolutely.
Because I do know, in my space, I won't reveal much, but those pieces of legislation that were signed, I think 90%, we are challenging them from the law society perspective. So I do know that, because there's a lot of constitutionalism in it. It doesn't conform the constitution. Number two is even the process of legislation, the public, you can see it's strange to most people because the public not participate in saying you hold an open check for a land tenure system, which you bought at the time. You then change it by sheer discretion into what we call a leasehold land. I mean, from freehold and many other things. But remember, even then, because I'm sure nobody legislated with a data on his desk. So there are banks that, for instance, are financial institutions that have invested within a context of a tenure system called freehold. And that is just one, and many other activities on the utility of land. Then you say you're going to convert that on a leasehold. What you are doing is abusing that space. All right.
Abigail, we look at a law that has been broken down here now. It is a legislation that someone wants to take advantage of to do whatever it is they want to do with it. But if you just look at what that means now to sector players, so let's look at real estate, let's look at farmers out here. And here is a situation where if I want to do anything with my land, the cabinet secretary must have a say. I could be right or wrong. Here's a question where these powers that Kenyans, in their own knowledge, decided to give these powers to the National Land Commission, NLC, these powers have been taken away from the NLC. And one asks the question, if NLC does not have this power, what is their role? And what does that then mean to the decision that Kenyans made to have that embedded in the constitution as a safeguard from abuse that Wakili is talking about? So just bring us up to speed in terms of, you want to put up apartments.
Yes.
How do you go about it?
Actually, there's also another side I'd want to look at as I answer your question, because when they say public land, the biggest fight we have at the county level as private developers with the county government is the understanding of what public land is. For example, you have 5 acres. Then you want to do a controlled estate, build a few mansionettes or bungalows, Then you have to allocate some public utilities for the residents inside there. So you want to put for them a clubhouse or a green space for them to just chill, as is the requirement of the law. What the county government, most county governments have been doing is saying, no, that is public land. You're supposed to surrender it to us. It's the biggest, we are in court with them. Like in Kiambu County, we are constantly always fighting with Governor Wamatangi on the same, And so when we now vest powers to the cabinet minister to say she's a custodian of public land and very key documentation, it is even giving her that power to say and come inside our private sector of real estate and say, it is in our own view that this is public land. And so then we will again start asking, based on the provision of the law on how government can do compulsory acquisition, are you guys going to buy this land from us? And of course that will not be the case. They'll say no, because they can also even stop your title processing of that specific estate because you have not surrendered what? Public land. So it will affect common mwananchi like that. Even as you're doing your subdivision, hereditary subdivision, you want to just give your kids land. And in the county that you're operating from, they've already said, like in Kiambu County, they say any acres are 50 acres and above. This is a county bylaw that was passed that we are contesting in court in conjunction with LSK. We are happy they've agreed to enter into a constitutional petition with us, because they say 50 acres and above, 20% you have to surrender as public land. So then it's now giving the cabinet minister now right over private property. And again, that contradicts the rights of private property ownership in Kenya. So how will that affect the real estate industry? One, first and foremost, that uncertainty that titles will not be processed because there's a friction of what is private land, what is public land. And government outrightly just stops your processes. So financial institution can't offer mortgages. Investors will not buy in an industry that has uncertainty of the title. And so many, during this regime, we've seen titles being revoked left, right, and center. We can no longer brag or securely say, as an industry, we can trust title processing processes, or a title deed is supreme. That is down the drain completely. And then this other aspect has come to being, that a cabinet minister can sit in her office, look around the country, and in retrospect, just decide what is public land and take it. And if they won't take it, they'll force you to give it out, because they will not issue you with title deeds. They will just frustrate you. And that destabilizes our industry, which affects the financial institution, because they will not offer mortgages on an industry that is quite uncertain and quite unstable
and that would mean as well to a private citizen that I have my own land. I want to develop it. I've gone to a bank to ask for a mortgage, a facility. But with that, the bank has requirements. I have to surrender title deed. But the cabinet secretary has said this is public land. That means a lot of individuals in this country would not be able to continue with their normal lives and businesses, because the cabinet secretary has decided that your land is public land. Am I right?
Yes, it boils down to that.
So then, in terms of now the development of the real estate, because I think the largest consumer of more of the urban land, both private and seemingly public, because by proxy, the amenities that are public are enjoyed by the private by the citizens. Yes, it's true, it affects how now the operations are running, because you're a bit hesitant to invest. The financiers are hesitant to invest. But what would be your basis now as an industry? Even beyond the revert, if you're successfully able to reverse this law, how do you have safeguards moving into the future? Because we've had cases, you mentioned the one from Roiro.
Yes.
And I think sometimes last year we had the other one in Jiro, which was like 3,000 acres.
Yes.
Kenyans, innocent Kenyans just come out, somebody is selling land, you buy, it's not even titled, you get a certificate, because the office assures you we are still in the process. You buy, you invest, you build a school sometimes, it's a private school, it's licensed by the government, and you must have proved ownership of the land when you are getting all these licenses to operate. Then years later, or months later, or sometimes later, the same government comes and says, this land has dispute, you have to vacate, because according to the court, this is the person who is now the rightful owner. How does that safeguard both the investor, the seller, and now we anchor it in law?
Actually, the only place where we get a lot of sort of justice is the court system. And we are very happy with that. That's why we are very worried when we see a whole acting government wanting to centralize a lot of powers to the NLC to decide on very serious and sensitive cases. But the most amazing thing is how government always gets out of it scot-free. And they are the center of land searches. You search land through the same government. They are the custodian of these processes. You pay stamp duty to them. Land rates are paid to the same government. But when revocation of titles happen, they are exonerated from any liability. They do not play a role in compensating the innocent investor. Actually, the investor is taken back to the drawing board by the court to renegotiate again with the aggrieved party and pay again. The most the court does is try and lessen the burden and say, please don't charge them the market value, be fair, and give them a longer payment period. But then it still boils down to now you as an individual, Dennis, you go now renegotiate again with the family that and say, mutanilipisha pesa ngapi? Mutanipea tu, unaanza kulipa tena afresh. That and just excusing government from their role is the most obnoxious thing we've ever seen in this country. And it completely destabilizes our industry as real estate. Because this is the same government we run to do our searches. It's the same government that financial institutions go. Because most people feel safe when you buy, from a development that is charged from a bank. But we've seen even the bank processes are no longer safe. Because even in the Ruiru case, there were banks, financial institutions, SACCOs, banks that were involved and gave mortgages. So are we saying even their processes are defective? And then when everything falls apart, government is there effecting.
So there lacks institutional responsibility.
Completely.
So, Wakili, a while back, I think it is Kibaki's regime, they said, or the onset of the Huru regime, that idle land ought to be utilized to plant trees or something, lest you start incurring some tax, which came out as some sort of revenge or vendetta against people who owned big chunks of land that were idle. And yet, in the same constitution, gives me rights to own as much property as I can, because it's a capitalist system that we have, so long as it's within the law. But now, looking at all these balancing of the historical injustices of land, privatization of the beaches, we're beginning to see that. What, in terms of legislation, what would be the ideal situation when it comes to land management for our country, Kenya?
I think the problem we've created for ourselves as a country is to give aesthetical value to land, and that aesthetical value is transferable from one person to another. The custody of land ought to be, all land is to the public. You can only have utility within a certain safeguard or timeline. And therefore, everything has to be on lease for government and the people of Kenya, because eventually we can't have the entire country as private land, and therefore its management becomes an account of supervising private people on how can they use the land. But since we are already there, the capital element, and this is from inception, when the country was handed over to us by the white man had passed land on account of certain fiefdoms that belonged to them individually. And therefore, you take from a white man an existing regime. By the way, after independence, when we had our own constitution, we transited 100% of the colonial laws. 100%, and those are clauses that we put, that all laws that exist pre-independence shall remain laws applicable to all Kenyans. Up to today, meaning therefore all land laws then transited with us. Of course, we've had quite some turmoil in terms of amending them until what we have today. So, problem is, private rights are private rights. For instance, if today you left this employment and were paid 8 million, and you said you can put 8 million in a fixed deposit account, seems good. But look at the dangers, and they're like, but look here, I come from a certain area, there's some 50 acres being sold, that 50 acres can pay 8 million. I think that's cheap. 50 acres for 8 million, no. Hell no, I need only 10. But the other 40, let me invest in them. When my son gets to university, I'll have money, I will sell and educate him. Isn't that utility of land? So why do you tell me I have to plant trees? I mean, I don't have to put money in a circle, I don't have to put money in a bank. I have bought land so that I can sell it. You are the one who said I can transfer land for value, so that I can sell it, and then I can educate my children abroad, because that's what I want. That's my investment. Is in that utility of land. So why tell me what to do with my land? It's private property. I can do what I want. And by the way, buying land and living idle is an investment, because one day it will appreciate or depreciate. I can invest shares in some Nairobi Stock Exchange. It can go up. It can go down. So don't tell me what to do with my money, provided I've paid your taxes. But because it's an asset, there must be a point upon which I'm responsible to government for asset, because it is maintaining security maybe. There's water supply and piping and all that. I agree with that there must be a tax element to it at transactional point. You see, there must be an output on a tax, a dispensing. So when I buy water, VAT, blah, 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 blah. When I go eat in a restaurant, I pay taxes. There must be a dispensing point, an output of sorts. So when I'm having my land and I'm idle, don't tell me produce so that we get taxes from it. No, wait until I sell it. Wait until I'm constructing it. Wait until the day that I'm taking my child to university and I sell the 40 acres that I've told you contextually here. Then you're going to get your money.
And I think,
but don't tell me you're going to tax me for waiting for the day that you will tax me again. I mean,
you know, there is a landowner here, Okari. You're boiling nicely.
No, me, I feel I'm going to get affected. And my questions are very, very basic. My questions are this as well. For someone who owns land, let's say 5 acres, 10 acres, for purposes of speculation, you've just purchased the land, you have your title deed. Maybe you're thinking in the next 5 years, 10 years, I'll subdivide this, sell to people. And like you earlier said, maybe I want to give this to my son, to my daughter, this person, that person. I'm not developing. I'm just buying it, keeping it, speculating. I'm not planting trees. That's not my intention. For however long I want to do it, 10 years, 20 years. And let's say it's a freehold land. You've paid all the taxes that you need to pay. You have your title deeds. How are people, because a lot of Kenyans do that. A lot of Kenyans have bought land. Ukwathi River, you go Syokimau, Ruiru, Thika, Suswa, you go these sides of Kitengela. There's a lot of development happening. And there are people who are taking their pension to just buy land, build their retirement homes. How is this law going to affect these people? How are they going to get affected by this?
I think what the law is saying, and ideally what the law is, of course, you always have to do your due diligence on the land that you're buying. And of course, you do a search, but the court is now saying go further and look at the transfer history so that there is nothing fishy that happened in that transfer process. And they've done this in their presidential cases, like the one in Ruiru, the Kirima case. They said, no, you guys should have been keen enough to look at the green card, see if there was any irregularities in transfer from company A to B and so forth. So it means the public has to be a little bit more vigilant in their due diligence processes. So you can't just rely on a land search anymore. Even if it means going to talk to the village drunk, because they always have the history. I'm in real estate, and there are some, stakeholders I can't ignore. First, do your due diligence in the right way and ensure you've covered everything so that you are not purchasing land that has ever been perceived as public. That's one. Or there is even any room for government to show up and say, this is public land. Because that's it, you lose your land. It's as simple as that. And it will mean either they agree you stay if you haven't made any development and you purchase again from them. That is what it means. Two, it also depends on which county you are in, because also counties have passed their own laws. For example, in Kiambu, where I operate and I'm able to guide, I can tell you if you have a 5-acre land, there's some percentage of land you need to surrender to agriculture. That's what Wamatangi is saying, because he wants to improve and sort of just spearhead the agriculture agenda. So like a 10% of it, you have to dedicate it for agriculture. Is he going to support you for agricultural practices? He's not promising you that. But he just wants to come out of that 5 acres as you're subdividing, iko shamba ya agriculture, apate iko kitu tu naeka. So in his own thinking, he knows once he does that, he has supported agriculture. We have reclaimed agricultural land, which goes against every rule of decongesting Nairobi, because Kiambu is the bedroom of Nairobi, but that is a county law. You need to be cognizant of what other counties are passing in regards to ownership of land. And even in spaces where the law is very clear, you cannot pass a county law that contradicts the constitution. They are doing it. And unless people are woke and they are able to go and contest it in court, they are getting away with it. This has even gone further in terms of land rates payment. There was an act that was passed into law, the National Rating Act, that gives counties more powers. That if you're not paying land rates, they can put your land under receivership. Dennis. So to get to EV 2, 3, 4 years, you've not paid them, you'll find it under receivership, and they're selling off your land, right?
Yeah.
It says that.
So Akili, like what Osman is saying, okay, so you have a Land Amendment Act. Then you have now counties deciding, okay, if you have, in the case of Kiambu, you have more than 50 acres of land. You give how much?
20%,
You just
10
give
to 20%.
20.
Yes, for
You give-
agriculture. Yes.
You're giving the county, or you're doing what?
No, you
hive off 20
You hive it for agriculture,
agriculture.
and they send enforcement officers to actually ensure that you're doing that.
So for people who already own land, like I said, for speculation, or maybe at some point you want to put up apartments, this Amendment Act, how does it affect the people who already own land? Whether it's 5 acres, 10 acres, 20 acres, whichever part of this country they belong to.
I think we should talk about the potential effect, right? Being that we've handed over discretionary powers to government officials on matters, private property, especially land. One, the government I have seen has enforced something called the doctrine of escapement. The doctrine of escapement is where you have land. It's called idle land because you're not there every day, right? That's the perception and conception of the word idle land. So you move to, let me just give a theoretical example, to CNN for 25 years, 18 years. Your children go to school there and everything.
Yeah.
Now you're coming back to Kenya. So is idle land in the context 3 years or 7 years? Or those 25 years that you say at CNN and you work in the US, all right? So when you come back, the discretion, the cabinet secretary has a right to declare it idle, and therefore the doctrine of escapement is where the government can repossess your land.
And I bought that land.
Yes.
And
it
on
can
my title
yes, it can repossess your land where you haven't claimed within a certain period of time. All right.
What does
Number two. So somebody dies, and then you can't find a relative to take the land immediately, because some kids can go to the US and stay. And by there, of course, it's a problem if you abandon your parents and you don't talk to them. But that can happen. So when you come back here, doctrine of escapement set in and the land was taken. So the danger is rife. It's available. It's immediate. It can affect everyone. Then the most important thing is, probably even worse, is the discretionary powers to say this is freehold, it's going to be leasehold at a discretion. Obviously, because of obtaining circumstances at the discretion of a powerful cabinet secretary on management of land, because we've made an absolute power out of a cabinet secretary. For
this conversation where it's leading, for the last 1 hour, from my reading, and I will dare say this, from my reading, this thing, you vest all these powers to a CS. Who is a CS answerable to?
The president.
The president.
Political
who assented? Who actually passed this?
President.
It's the president. So this CS can make a decision without consulting anyone that I'll cut off a chunk of a piece of land in whichever part of this country, let's say 20 acres, and I can declare that land to be idle. Like you said, whether it's 2 years, it's 3 years, or take public land and give it to whoever wants to own your shamba,
and do affordable housing.
And do affordable housing and build up apartments or hotels or whatever. That's essentially what you're saying. This gives the CS powers then to decide to come and take Zuena's piece of land and build whatever they want to build.
I think you're being nice.
Please
why don't you say it gives the president powers, because the president instructs the CS. So simply we are vesting back
power to the
president, which we took away.
Because that's what I'm saying. The CS answer is
answerable to the president. So the language is the language should be what we should be seeing is the president has is obtaining power through the CS. In of course in layers, but obviously it cascades from him.
So the president is taking us back to pre-2010 constitution.
But of course, we're vesting power back to the president.
So in my opinion, as a person who is not a lawyer like you, this seems like a rogue land operation scheme that is out to defraud and mislead Kenyans and the land management of our land as a country.
Put it the other way, I think it's a politician's decision, so a leader's decision. So the politicians would want to thrive, dominant, basically dominate over society, conquer and dominate. That's really what is happening here. The process is purely to conquer and dominate on the populace, as opposed to the leadership, the intrigues of, management of land in the private context, vis-a-vis, complementing investment, the economics of land, and obviously sorting out the historical injustice, because there's so much to do on the land area as opposed to legislating on this. And number 4, what was the urgency? What is it that was supposed to be fixed until you pass such laws? What is it that you intend to achieve? If you ask you and me, there's no clarity, except something mischievous that we don't know.
Seems like you ought to make Zuena a subsistence farmer.
And it is a conversation that we must have, because you look at even what our listeners are saying here, that mambo imechemuka, and a solution to that is, I know there is a matter in court, and perhaps a conversation that needs to continue for people to continue speaking, but most importantly is we must have a plan.
Let me caution this, probably, sorry to cut you short. If it annoyed people that a bill was increasing taxes, they should annoy people even more. Because it's a lifelong problem.
Okay. Okari, you have a plan.
Then it means we have to make plans. So you are here listening to this show and you're thinking, okay, so what's going to be my next investment? Shamba, what do I do? There's another person who's already thinking about, okay, my retirement plan. So with these conversations and what we are seeing around the country, how do I then plan for my retirement? Well, I see a Lion is going to make that very easy for you. It's never too early and it's never too late to start planning. So I see as a plan for everyone. So my question is, what's your plan? Now, here you could be thinking insurance and or investment options that help you grow, protect, and plan with confidence. I see a Lion helping you secure you today and build you tomorrow.
This is the Situation Room, the only way to start your day.